Good morning, everyone. Welcome to the WILMIC Fall Seminar. Given the weather out there, I guess it feels more like the winter seminar, but in any event, we're happy you're here. I also want to welcome the 130 people or so who are joining us on the web. I will have some instructions for the web people in just a moment, but for those of you who are here, again, thank you for being here. The program is titled Solo and Small Firm Roundtable. What keeps you up at night? Are you getting the most out of your practice? What we did was we sent out a survey a couple months ago asking lawyers what would they want to talk about or what do they want to hear about at a seminar of this type, and we got a lot of responses back, and so there were a lot of suggestions on the topics, and so that's what we're going to talk about. If you have other topics that we are not talking about or that are not in your materials and you want to talk about them, feel free to bring those up. Raise your hand, we'll get to you, and we'll talk about it. And that goes for those of you on the web as well. We're going to have two different sessions today, both lasting about 75 minutes. This first session will go till about 10:15, and then the second round will go from 10:30 to 11:15. I'm intending this to be a discussion, so again, feel free to join us. I want to hear what you have to say. Our panelists will want to hear what you have to say. These are most effective when we're learning from each other, so please feel free to jump in. The program has been approved for 3 CLE ethics credits, for those of you who might have been wondering about that. And I also want to thank the State Bar for giving us the facilities today. We very much appreciate it. Now, for those of you on the web, very briefly, you'll find a link to the written materials on your screen. Now, I understand that some of you on the web have had trouble downloading those materials this morning. I believe when you click on the program materials, it'll ask you to download them to your computer. So I guess I think the best way to do it is download it to your into a Word document or something like that. Is that pretty accurate, Phil? As a PDF? Okay. Hopefully that'll work. It's working here, so I'm hoping you all have a chance to do that. Also, you're going to see a link called Submit a Question, and if you click on that link, it will then open your default email client, and you can submit a question or comment right from your email client. So hopefully you can do that, and I encourage you to do that. We do have someone here who is monitoring that, and if you send us a question or comment by email, it'll get to us, and we will take it on for you. All right, so let me give you a quick roadmap of what we're going to do today. As I said, the first panel here will run till about 10:15. We're going to talk mainly in this first hour and 15 minutes about things like client screening and selection, effective communication with clients, engagement letters, online lawyer reviews, client confidentiality, fees, and some limited scope representation issues as well. Again, that's sort of our focus, but if you have other issues you want to talk about, bring them up. The second panel is going to focus on lawyers, how they get into trouble and how they can avoid those pitfalls. So we'll talk about that. We're going to talk about practice management issues in the second panel, technology, lawyers using social media, dealing with difficult clients, billing, and file management. So that's sort of the agenda for the second panel, and Katja Kunska will be moderating that panel. Let's get right to it. Our panel for this first round, I have, I think, 3 really distinguished lawyers who I've known for a number of years, and my job as moderator will be to kind of stay out of their way and let them impart some of their wisdom to us. First, on my far right is Kevin Palmersheim. Kevin is a managing shareholder at Haley Palmersheim in Middleton. That is a 5-lawyer firm, Kevin? 5-lawyer firm. Kevin's practice is concentrated in the areas of business law and litigation. He received his law degree and his master's degree in business from UW in 1992. Kevin represents, for the most part, clients in business disputes. He's also called upon by other lawyers and law firms to advise them on law firm formations, and breakups. Kevin has served on the Board of Governors. He's a past president of the Dane County Bar Association, and he's a frequent speaker and author. He's also been recognized by Wisconsin Lawyer magazine, also as one of the best Wisconsin business lawyers by Milwaukee magazine, and also one of Dane County's top business lawyers by Madison magazine. So Kevin, thanks for being here today. To Kevin's left is Diane Diel. Diane is a family lawyer in Milwaukee. She is also a UW Law School graduate, past president of the State Bar of Wisconsin, past president of the International Academy of Collaborative Professionals. She is a current member of the State Bar of Wisconsin's Ethics Committee and of the International Academy of Collaborative Professionals Ethics and Standards Committee and the UCLA Ethics Task Force. Diane served on the Board of Governors as well. She's a past member of the Family Law Section Board at the State Bar. And Diane is also a frequent speaker and trainer on ethics topics and collaborative practice topics. And Aviva Kaiser, to my immediate right. Aviva is Assistant Ethics Counsel at the State Bar of Wisconsin. She has taught at UW Law School for the past 25 years. She teaches professional responsibilities and also taught ethical and professional considerations in writing, problem solving, and risk management. From 1992 to 2002, she was the Director of Legal Research and Writing. She received her BA in Chinese from the University of Pittsburgh and her JD from the State University of New York at Buffalo Law School. She practiced in Chicago before embarking on her teaching career. So thank you all for being here. All right, let's get going. I'm going to start with you, Kevin. A lawyer at the Solo and Small Firm Conference a couple years ago made the comment to me. He said, you know, if not for the clients, I'd really have fun practicing law. So I guess I'm taking that as meaning that he likes to practice law, he just doesn't like his clients, which is a tough way to go because without the clients, you know, you can't practice law. I guess, you know, it made me think about the whole notion of client communication and client relationships and how lawyers foster that type of thing. And so I guess, you know, in your practice, being a business lawyer, your clients often are more than one person. You have multiple personalities, and so how do you effectively communicate with those clients? And you know, how do you get them on the same page with you, manage their expectations and demands, and that sort of thing?
Well, I mean, the first thing I tell them is it's really important to be on time. So.
And do as I
do.
say, and not as I do.
Yeah. It is true, and communications, rather than the ABCs of communication with clients, I kind of call it the CBAs. You've got to have some compassion, but you have to set boundaries, and then you have to give advice. And it is true that a lot of times, you know, I have multiple people in the office, but and I'm sure some of you experience this too. I'll sit down with the initial client meeting and talk to them, and when they leave, they just feel so much better. They've got a problem, and they've unburdened themselves of that problem, and they feel like they've got somebody that's going to help them with it. And just showing a little bit of a compassion in those communications can go a long way. And this happens even in the business setting. You know, business, I do a lot of family business disputes and a lot of business breakups where the emotions, maybe not quite as much as what you would deal with, Diane, in divorce, but a lot of it is kind of the same type of thing. And because of that, you also have to set boundaries with your clients because every issue to them is an emergency, whether it's been sitting on their desk for 9 months and they tell you they need something in 2 days, or whether it truly is an emergency, and you can't let that pull you in because it's just way too stressful when you're communicating with clients, and you have to remain objective and then give them advice. I have 2 new associates that I'm training, and one of the things that I'm dealing with and teaching them to communicate with clients is they give the law school answer to the clients. They say, well, here's all your possibilities here, these 8 possibilities. Clients want to be told what to do. What's your recommendation? And I feel like when you communicate with clients, you need to give that advice. So I guess that's what I start with when I communicate with clients.
You said they want to be told what to do, but do you find too that in this day and age with and Diane and Aviva, you can jump in on this too, that they're more knowledgeable, or at least they have consulted the internet and these self-help sites, and so they think they're knowledgeable, and so they come in not so much needing direction, but rather giving direction to you.
Yeah, you got to tell them things that they don't want to hear, because they do often have an idea of what they want to do, and you have to listen to them, and that's where you have to be careful too, because you can run into difficult clients. That way, if they're going to try to run the whole show. I do represent a lot of law firms and lawyers, including in breakups, and I will tell you that they are some of the most difficult to deal with. And it's because they haven't just gone to the internet. They really do think they know what to do. And you have to tell them, well, that may not be the best approach, and be diplomatic about it.
Yeah. Diane, as Kevin said, you're in the family law arena, which is highly emotional and
highly emotionally charged. Most clients who come to see me at the outset of their divorce or family law matter fall into one of two categories. There's the person generally who is initiating the divorce, and there's the person who is, of course, surprised or stunned. We like to talk about them as the leaver and the leavee, and there is a host of difference in terms of dealing with one or the other person. The good news is that more and more people are trying marriage counseling before they decide to divorce. At least I find this in my practice. I get a lot of people in who've actually processed through some counseling and even some exit counseling for their marriage. But you'll find that people in a family law context are, of course, at very, very different places. Some of them are absolutely well-armed and informed. I recently met with an individual who had outlined his entire marital settlement agreement, including some very difficult and complicated ideas about how to divide his pension, which I think is a matter of a great deal of expertise. The point about dealing with people at this emotional vulnerability is to let them know that there is, just as Kevin says, compassion, and that you can appreciate their difficulties, but setting reasonable expectations for them. What are the expectations? I spend a lot of time, from 90 minutes to 2 hours, in an initial consultation with people. In those consultations, I try to be certain that everybody understands that they will get to tell me their story, but I need them to also hear about process option choices. They need to hear that they have different ways of going about resolving their divorce, and they also need to understand that a lawyer can only provide so many of the answers. I hear Kevin say they want to be told what to do. That is classically true. I don't know that I can always tell people what to do. I do need to look at options for people and directions to take, various process choices, and how do they make those decisions. I think the best thing that I can do for people is, instead of the 8 options that your associate's throwing, I hopefully can bring people down to 2 or 3 options and let them, with information, form their own opinions.
What are the biggest changes you have seen, both of you, in terms of the way clients react to you, or the demands that they bring in, say from 10, 20 years ago? Is it different, and if so, how?
Well, Tom, I think you hit it on the head when you talked about the internet. A lot of the clients come in with a lot more sophistication or knowledge than when I started practicing in the early 90s. So that can be helpful. It really can be helpful when they come in and they've already looked at some issues, and you're talking about terms that they can understand, or at least have they read a little bit about. But then I think Diane's point on expectations is important, because if they've done a little of their own research, you've got to explain what the realistic expectations are. Just because they found this reported case in Oregon that is favorable to their position doesn't necessarily mean they're going to prevail.
Mm-hmm. Diane, your views on it?
I totally agree with that. But I also want to say that one thing that I've started doing is, while clients screen you, they come in, they've got your resume printed out from your website, and they've check 6 referral sources. When I used to ask people, how did you get my name, they would name one person. Now they say, well, you came from 3 or 4 different sources. They've really done their homework and screening. My response to that is that I, in effect, screen them back. I do a phone call before I even let them come to see me for a consultation. It saves a host of time, and it really minimizes no-shows on consults. And I charge for my consultation time, and I tell them that, and they know that they're going to have a flat fee consult. But when we talk, I can redirect people who clearly aren't going to be able to fit into sort of either the ability to pay my fees or the ability to work with me and communicate well with me. So we are scheduling now within a few days of an initial client phone call, or regrettably often emails. They try to set up initial meetings by email all the time. We are scheduling an initial conversation that I will give up to half an hour of that amount of time. And I often find myself redirecting clients to better resources for their troubles or their particular needs. So that's one way that I'm trying to assure that I'm meeting with people who will be a good match for the practice opportunities that I have and for my style. I let people know right away that I don't see their divorce as the next big U.S. Supreme Court battle, that I let them know that what I see their divorce being is a problem to be solved, and the question is, how do we solve that problem? There are pretty limited parameters around those solutions, and they're better off if they tailor their own. That's my message to people, and it leaves me with a clientele that is better matched and suited to my own personality.
I guess one of the early tools, in communication would be the engagement letter. And Aviva, why don't you talk a little bit about that? I guess that's a good place to start, huh?
So, George, just a transition, is the place where you can show compassion, believe it or not. You can structure the communication, you can structure all those expectations. But when we talk about them, I really want to distinguish between what's required by the rules and then what is good risk management. And so I knew that you would like to hear that from your perspective.
Absolutely.
But, so there's really only 4 things that have to be in writing. And so the first one is when your total cost of representation exceeds $1,000, then what you have to have in writing is that scope of representation, the nature and basis of the fee that you're going to charge, and you have to include what the purpose and effect will be of those advance fees or retainers. But that's the only thing that's required in writing for that particular instance. If you have a contingency fee, then you have more that's required in writing, right? You have to, and it has to be signed by the client. But again, you have to have in there the nature and the scope of that representation. You have to have how that fee is going to be calculated, what percentage. You have to include whether your expenses will be deducted before the fee is calculated or afterwards. And you have to explain that when it's over, you will send them the bill or the final accounting. So that's the second thing but again, very limited what you're required to have in writing. The third thing that you have to have is when your fee changes. So if you've been representing a client on a regular basis and then that fee is going to change, regardless of whether that fee had to be in writing at the beginning, the nature and the basis of that fee, if you change it, there has to be a writing. But that can be covered on your invoice. So again, it's not a full-blown engagement letter that's required there. Now, the last one is after January 1st, 2015, you will be required to put in writing the informed consent for any limited scope engagement. So that's the new rule that's coming down. And it will be under 1.2C was amended. And that will also include the scope, because informed consent requires, as it's defined in 1.0F. And by the way, if I use a rule, it won't, I'm leaving out the 20, SCR 20 : I'll just refer to 1.5 or 1.2. But anyway, that informed consent has to include the nature of that representation, all the risks that's involved, and the reasonably available alternatives, and enough information so that that client can make a choice. So those are only the 4 things that really have to be in writing. So what you're going to say is Kaiser crazy? Why is she recommending that we do these engagement letters? And I think you'll see the outline there is maybe 48 pages. And that was more than just to see you got your CLE credit. But the reason for those letters of engagement, number 1 is risk management, but 2, setting the expectations for the client, getting that information out there. And we don't have time to talk about all of it because we've got a lot to do. But I'll give you a few examples. Communication. Communication is probably the most frequently complained about issue with lawyers, or the lack of communication, probably I should say. But so having in your letter of engagement a provision that says, here, if you call me or contact me by email or text me, I will get back to you within 24 hours. And then have a provision if it's an emergency, what will happen. That sets those expectations, and then you can stick to them. Another area is the attorney-client privilege and confidentiality. Right now, with all the internet usage, with email, all the electronic communication, what that means is we have an obligation to tell our clients that they need to be careful. First of all, it's so easy for them to push the button and forward that email you sent them to mom or to a friend. But what does that do to the attorney-client privilege? Waives it, right? And in terms of just confidentiality, do you want us to constantly, have that information that we're sending our clients sent? So putting that in your letter of engagement is really crucial. Another thing that's crucial is if we are required, and competency requires that, and communication. But if, it's an ABA opinion, and it's in the materials, if you have a client that may be in a divorce case or in an employment matter case, you need to tell that client that what the risks are if they use either email or a computer that a third party has access to. And so that's actually required that we say to them, here are your risks if you do that. And just another example of, let's see, what do I want to talk about? Well, I guess that'll be it, because I know we have a lot of time. Client responsibility you talked about, right? So we can put that, oftentimes in a letter of engagement, when I was working with my firm in Chicago, our corporate clients weren't always the most responsive. So one of the things we did is we had in our letter of engagement, here are your responsibilities. Because oftentimes they think, oh, here we have all these interrogatories, the lawyer will write them, answer them, right? Can't do it. But the other big thing is file retention and destruction. We find that older lawyers did not have policies. We're being called now that there's so many files and they don't know what to do with. And do they have to contact all those former clients before they can destroy those files? Well, the good thing is if you have that file retention and destruction policy in your letter of engagement, you've satisfied that.
How about communication expectations in an engagement letter? In other words, what I've heard lawyers talk about is some clients think they can text or email them anytime, and they should get an immediate response and things like that. So some lawyers I've heard talk about putting that in an engagement letter. In other words, if you email me, I will get back to you within 24 hours. But, or they set parameters. So.
Right. And that's a good thing to do, because then the client, you get that discussion with the client at the outset. You can do it with compassion and explain why you have that policy. But if there's an emergency, that they can contact you, and how you can talk about what an emergency is and what it isn't. But also, that's the great place to say, I won't do texts. If you don't think that texts are appropriate for that representation, then we're not going to do texts. And it's also important to talk about, again, that communication by email and the care that's needed.
Diane, Kevin, do you guys put that kind of thing in your engagement letters?
I don't put it in my engagement letter, but I do then convey later on that I can't communicate via text. That I will do email, of course. I mean, you have to communicate via email. But part of the reason I wouldn't put it in my engagement letter is because engagement letter is not just to set out the parameters. You're also trying to get the client. And I don't want to scare them away because a lot of the newer generation, they communicate via text. And if you put a lot of that negative information in an engagement letter, from a practical standpoint, that might scare off a client. So I don't put it up front for practical purposes, but then I do let them know later on.
I don't use it I don't use that kind of set of parameters in my fee contract either, but what I do is I set very clear expectations and conversations with clients. My view about texting is that, hey, I've been dragged kicking and screaming into an email universe, into an internet universe, and you know what? They'd have to have my cell phone number in order to be able to send me a text, and they won't get it. They really won't get it because Kevin brought up the word first, boundaries. You know what? Lawyers need to set careful boundaries with particularly their family law clients. For years, I've thought about the really stark contrast between what it would be like to have business clients with whom you have an ongoing, recurring relationship as compared to the, to use the British expression, the once-off divorce client. So I don't make friendships with my clients. I set those boundaries very clearly. They know that I monitor email relatively closely, and they will be told if I'm going to be away from email for an extended period of time. I have the luxury at my age now of traveling fairly extensively, and when I travel, I let people know in advance that I will only infrequently be monitoring email and what they can do, that they should contact my office and my assistant should an emergency arise in my absence. So I think setting expectations and then living up to those expectations is about the most important thing a lawyer can do to establish a solid, comfortable relationship with a client.
Okay. Questions, comments? I guess we talked client communication. Maybe we skipped over the step before that, which is selecting the right clients or client selection just on its own. And Kevin, I think you alluded to it, trying to get the clients. And so, talk, if you will, about client selection. What goes into that? And I know Katya and Sally have both use the phrase "no" is a complete sentence. So sometimes maybe that's the best way to go sometimes, right?
It is, and I had that happen a couple of times yesterday, as a matter of fact. When you get that call that says, the past 3 attorneys I had didn't understand me, but I'm sure you will, then that's a good warning sign right there. There is a luxury in being able to turn away potential business too, and I recognize that. I wasn't able to do that when I first started practicing, at least not as much. But I've also realized, and I convey this to the other attorneys in my office, you don't need more business, you just need good business. And it's the 80-20 rule is 80% of your headaches as an attorney come from that 20% of clients who cause you the most grief. And even sometimes when they're profitable, it's not worth it. Kathleen Dettmann, who's in the second panel today, she and I had a case earlier this year. It was a limited engagement with a client. It was 2 months. It was a temporary restraining order, temporary injunction, sophisticated business case. And 2 days after I took the client, I regretted it immediately. And it was probably the most profitable 2 months that my firm had ever had in a billable hours basis. And if I had to do it over again, I wouldn't have taken it. And those are situations when you realize when those clients are going to suck the life out of you, it's just not worth it.
What were the issues, without getting too specific?
It was a $100 million merger of a business, and a minority shareholder was trying to stop it. And he actually had grounds to stop it, the merger. And He had dissenter's rights, which means that he could object to the merger and get paid fair value for his shares. And the problem was that he didn't come to us until a few days before the merger was going to go through, and that was caused by the fact that the company hadn't told him in the requisite amount of time. So we had grounds to stop the merger, but what I discovered after talking to this guy for a couple days is there's a reason why this company didn't want to have to deal with a shareholder. He was just incredibly difficult to deal with. He had high expectations, and it really did, just pull the energy and life out of us. And on top of that, Kathleen and I had to cancel a lot of our plans. She had 10th anniversary wedding anniversary plans with her husband at a B&B that she had to cancel. And those are things where you realize after a while in the practice of law that as Diane emphasized the boundaries, we need to keep separate from our clients. We don't need to be pulled into every one of their emergencies, and we need to have a life too.
I know from the perspective of solos, especially younger lawyers that we talk to, in various programs that we do, the tendency is, especially for solos just starting out, it's so hard to watch that business walk out the door. Can you talk about that a little bit? How do you tell a young solo who's trying to make it that it's better to watch that business walk out the door?
Well, those are the most difficult cases often to collect your fees, though, too. Mm-hmm. And in this situation, I think the only reason we were able to collect our fees so easily is because the corporation was going to have to pay the shareholder money, and that went through our trust account. And that's the best way to get your fees as a lawyer. But just because you've got the work and you're busy doesn't mean you're going to get paid. And those are also the types of clients that are most likely, probably Aviva could touch on this, most likely to file an ethical complaint or be difficult down the road. And that's going to cost you more in the long run. Whether or not you have insurance, it's going to cost you in time, deductible, emotional energy than any revenue you can earn from that client. So I try to tell those solos, and I do some mentoring on that those clients really aren't worth it in the long run.
Diane?
It's such a difficult temptation, particularly startup law practices. I guess if you have a doubt about the client, you really need to listen to yourself, and particularly if you have a doubt about the client, make sure that you don't work until you're paid an advance representation fee that, of course, you will manage according to the appropriate way of depositing to your trust account and billing against it as it's received. But make sure you have security for your fee payment because, frankly, sitting on the beach, that's a lovely thought today, would be better than taking some of those sustained engagement cases. Kevin's story made me think of a gentleman that I represented his ex-wife on an appellate matter. This man has been through almost every brand new lawyer in town and frequently engaged in self-representation, and has recently even figured out how to copycat the civil Gideon petition and petition the court for the appointment of counsel for himself in his family law case. I've never seen anything quite like it, but if he doesn't have every single warning symbol on him that could ever be created, and yet new lawyers are brought in. One lawyer even told the court, and we'll let Aviva comment on this one, even told the court, oh no, he's not paying me, we have a barter arrangement. So watch it. It's really simply...
He's going to teach her how to draft documents?
He's got some skills. He can do appeals on his own. He is an IT kind of person, so he had some IT skills. Was going to set up the computer system in that lawyer's office. So temptation is great, but if you can look at the risk-reward situation and ascertain what these warning signs actually mean, read those tea leaves. They're really important to follow.
Before Aviva jumps in, we have a question from the web, I believe.
Yes, you do, and it is actually for Aviva. The question is if you could give some more detail about the risks that need to be outlined in 5 minutes.
We need you on the microphone, Kaji.
Sorry about that. The question is whether you can give some more, please give some more detail on the risks that need to be outlined in the limited representation setting.
Sure. Do you want to do that now, or we're going to go to
we're going to get to that. So whoever submitted that question, hang in there.
Would that be all right?
We will get to that. Aviva, did you want to comment on the discussion?
No, that's okay.
Okay. Diane and Kevin covered it.
They did a great
Well, let's
job.
move to this. Oh, yes, sir.
Sorry, I have a quick comment.
That's okay.
One of the quick,
Oh, Mike.
microphone?
Yeah.
Thank you. One of the first signals would be when someone across the glass says to you, I'm going to give you Charlie's number. He'll tell you he was driving the car. That's an easy walk away. Also, I caught another case, like you catch a cold, code for I committed another felony. I find that's a quick warning. Those things are quick warning signs that it's going to be a problem. But the question I have is I heard some comment, and I'm sorry I came in a couple minutes late, about putting in retainer agreements or representation agreements information about when files would be returned after the closure of the representation and so forth. What about a situation where you, let's say, go back 5 years and you had a number of agreements that did not cover that point, and one is getting close to, let's say, retirement within a foreseeable period of time, and these files still exist, and no agreement was specifically made with the clients about it? Any guidance in that regard?
Sure. We have an old ethics opinion, and I think it's E98-1, and that ethics opinion suggested that you would have to contact, if you had no specific file retention and destruction policy in your engagement letters or in your closing letters, that's another thing, reiterate that in your closing letters, that you needed to contact all those former clients before you could destroy the file. Now, we're working in our ethics committee right now on redrafting that. Rule 116D, so SCR 20:116D, says that at the close of the termination of representation, you have to return everything that belongs to the client, and that includes the file. But there's nothing in there that says, and you have to protect their interests to the extent reasonably practicable. But nothing in that rule suggests that you have to actually notify them before you destroy the files. So what we're recommending is that those files be kept at least that 6 years. And the reason we suggest the 6 years is that's the same amount of time that you keep the documents for your trust account. If you like belt and suspenders, you can keep it for 10 years because that's the statute of limitations for OLR complaints. But if you keep those documents for that period of time, for that 6 years, and again, that's also statute of limitations for most causes of action, then you're pretty good. The other thing you have to do is go through those files. If there is any original in that file that can't be replaced, like a trust document or a will, or stock certificates, anything of value like that, you can't destroy those. So that means, and we're telling lawyers that they may have 20 years of files that they should go through to make sure that there's nothing in there. In fact, there's one lawyer who is now filing approximately 70 wills, original wills that go back to 1960, but the statute requires them to be filed once you discover them. So you'd go through those files, make sure there was nothing of value in there, and then when you do destroy them, the best thing to do is make sure it's done securely through shredding. One of the things we also suggest is that if you want to publish in a newspaper, if you're closing your office or if an attorney has died and you're assisting either through a Chapter 12 trustee, that you put a notice in a newspaper of general circulation for like 2 consecutive times that says the practice is closing. If you want your files, you can get them at this time, and then hold them for about 2 months or 3 months, and then you can destroy them.
Okay.
Is that anything you want to add to that, you think?
Questions, comments?
Good question, thank you.
Yes, thanks. Okay. Well, let's jump into limited scope representation. The web viewer asked about that, and I think the question specifically dealt with what to put in engagement letters with regard to the scope of the representation. Diane, you do a lot of this stuff. Let me start with you on this. Talk about, I guess, just generally, your view on how to do this successfully, and also addressing the question from the web viewer, which is, what do you put in an engagement letter?
To start at the very beginning, limiting the scope of your representation is only appropriate if it's reasonable under the circumstances and the client has informed consent. So informed consent, well, I don't know, do you have another 3 days? We can have another program. And if it's reasonable under the circumstances is, of course, also to me a topic that could consume a substantial conversation. If it's reasonable under the circumstances, that it's such a general and broad requirement that I think that it really requires the lawyer to look very carefully at the situation. So in family law, we're often called on to simply give advice in a once-off, in a consultation. People come in, they've got their papers there. We are exempted in that single consultation for less than $1,000 from writing up any kind of a fee agreement. I'm right, yes.
Well,
If it's
until January 1st, 2015, because then after that, you have to have that informed consent in writing, even if it is, and this is great because this is, most limited scope engagements are probably going to be under that $1,000, and so you think under 1.5B that you don't have to have it in writing because it's under $1,000. But unfortunately, 1.C or 1.2C now requires that scope and that informed consent be in writing. So the problem is that even though, so 1.5B1 says you have to have the nature and basis of the fee there and the scope of the representation. But if that's not precluded, or that doesn't save you from complying with 1.2C, which says for a limited scope, you always have to have that informed consent in writing.
So that would look like this.
Yeah.
The client comes to me, says, here's the motion that my spouse just filed. I can't afford an attorney, but I'd like to come in and meet with you for 90 minutes and get your advice about what to do under the circumstances presented by this motion. And in my first few minutes of assessing this, must I then say, you know what, I can't do it. I can't do it at all because it's not reasonable under the circumstances. I can't address the whole litany of what the content is in this motion. Is that kind of what you're saying? Or say, I feel very restricted. Spend some time in that 90 minutes writing the memorandum that says, you only engaged me to sit here, but I don't think it's reasonable.
Right,
Where are we going with this?
Well, and then also how you define what's limited scope. But there's 4 exceptions to the writing requirement, and as you were talking, I was thinking, could you fit with any of them? So the one is that it's solely a telephone conversation. Makes sense, right? The second one is that the representation is either part of a program that's sponsored by a bar association, a nonprofit, or a law school, and what you're giving is information and advice, or you're helping them fill out forms. But again, you're not part of that. Mm-hmm. So that doesn't apply. Then the third one is if the court appoints you for a limited purpose, and that's actually in the court order appointing you. And then the fourth one is public defender appointments under Chapter 977. So it does seem like right now that if that limited scope engagement is that one appointment to discuss things, the first thing they have to do is give that informed consent in writing. And the problem with that, what is limited scope?
Sure. The difficulty for me in that
or is that an initial consultation
live in
and
action
not limited scope?
I think it's coming in as an initial consultation, perhaps, minus my screening phone call, which would allow me to really formulate that. So when I started talking about it, I was thinking about it as an initial consultation. And it may well be. It may well be. So I think that the difficulty is how can you reasonably predict the reasonable consequences of limiting your scope. So, for example, collaborative family law. Limited scope representation, the lawyer's scope is limited to settlement negotiations only. And the requirement is that both clients sign similar limited scope representation agreements so that the parties both clients have the same chance of losing their lawyer if litigation ensues. So that gives everybody some stake in the staying at the table, negotiating, etc. The belief that I have is that it's not reasonable to limit that scope in that fashion if I believe that the client won't be reasonably able to sit at the table and make informed decisions, if I believe that the person is suffering from some personality disorder, dementia, which, by the way, that's a whole different topic about the graying of divorce. I'm seeing that quite frequently, elderly clients and divorces, or some addiction, alcoholism, whatever the difficulty is, that's a problem to be assessed up front. So informed consent to the client in the written fee contract, to me, can look like something as clear as bold-faced letters, I am engaged only to do this, versus a checklist. Tom and I have presented on this before, and many forms exist in the universe that basically have a checkbox. I'm going to help you draft your motion papers. I am not going to appear in court. And so it's a I will do this, I won't do this kind of checkbox. I worry about checkbox forms as something that are likely to be skimmed over and so forth. But you can find on the web and even through past state bar programs, current state bar programs, and I'm sure ensuing articles about this, a really nice variety of engagement letter formats.
So,
Yes, Janice, go ahead.
Question for you, Diane. The client comes in, establishes his or her wish to do a collaborative divorce. Your engagement letter says that everybody signs off. You then initiate overtures to the spouse and find out it's going to be a knockdown, drag-out, litigated case. Do you then change your engagement letter and have your client sign a different one?
In fact, because I do both litigation and collaborative work, both of my standard form engagement letters actually indicate that if the matter does not proceed in the collaborative process, we will execute a new fee contract and vice versa. So I have a similar but reverse clause in each of the two standard agreements that I have.
you know, and Diane brought up a great issue about what reasonable is under the circumstances, because when we think about limited scope, and we have to really change our view about what it is. So how many people do estate planning here? Good, so you'll help me with this. One of the things that is limited scope is if a client comes in and you say, well, I can give you the $500 version with no tax, you know, simple will. I can give you the $1,000 version flat fee, which has the will and some tax considerations, or the $5,000 version that will give you a will and perhaps, you know, a trust. And most often we won't think of that as limited scope. But if you have a client with a substantial estate and with, you know, very complicated issues, it would not be reasonable under the circumstances to do the $500 version for that client. Now we can change the facts a little bit and say that client doesn't have a will and he's going out of the country for a month vacation, and then all of a sudden that, you know, simple will may have to do and would be reasonable. But that is actually a type of limited scope engagement. Workers' comp is another type of limited scope engagement, because to be competent, and there are several opinions out of New Jersey and California, we don't have any in Wisconsin that I'm aware of, that says when you represent a workers' comp client, you are, to be competent, you have to tell that client, you may have other causes of action available to you, and we don't do them, but you should check that out. So even there, that's limited scope. Local counsel, for example, is limited scope engagement. And sometimes it may not be reasonable when the primary lawyer in New York says to you, you know, don't talk to that client. You know, talk to me and I'll talk to the client. But local counsel is also a type of limited scope. In litigation, actually, just earlier in October, the Minnesota Supreme Court held that their counterpart to OLR had no basis for finding that a lawyer engaged in misconduct when that lawyer had a limited scope agreement with the client to only appear at one hearing in a divorce case. Yes, sir.
Pro hoc vice, I'm in a border county, St. Croix County, and frequently go over in Minnesota and work pro hoc vice. Do I need a limited scope agreement after January 1?
I don't think so, because you're doing the entire litigation yourself, right?
Not necessarily.
Not necessarily. So, and that, what's that going to look like? That so if you
Usually in a personal injury and a fee sharing agreement.
Mm-hmm.
Thank you. But is a limited fee, is a limited scope agreement necessary?
I would say it would be, because you're not representing the entire matter. And the problem is, what's a matter, right? It's not defined in our rules. It's defined in the government 1.11. E defines matter for that. It's also defined in the comment to 1.9, the same or substantially related matter. But we're also told in one of those comments that a matter can shift or change. So we don't really know. And some of the concerns I have with this rule is that almost everything looks like it may be limited scope at some point.
Thank you.
Yeah,
You're welcome.
That's my reaction when you're talking about it. If you talk about the non-litigation setting, I mean, every matter starts out as a limited scope in some definition.
Right. So there's that great transactional case that came down in New Jersey in September, where a very sophisticated business client negotiated a complicated deal for a sale of a company. He hired the lawyer, and the lawyer was supposed to be sort of the mere scrivener. The lawyer was found, a summary judgment in favor of the lawyer in a malpractice case was reversed by the appellate court, because the appellate court said that they couldn't say as a matter of law that that lawyer fulfilled his duty to the client when that lawyer did not explain an unambiguous term in the agreement that the sophisticated business client negotiated. And they said it was a limited scope, and in the agreement there was a limited scope agreement, but the court said it couldn't say as a matter of law that that was a reasonable limitation. But yet, in 2003, in a divorce case, which was really interesting, a client, a woman who was unrepresented at mediation, she sued her lawyer. Her lawyer had a 2-page limitation agreement, and that agreement included that he would not look at the income tax forms, he would not look at any of the valuation of the property, and there was property in Taos and Vail and all these other places. He would not look at any of the stock valuations, and he would not make a determination whether the allocation of the property was appropriate. All he was going to do was look to see if the agreement as drafted by the mediator was clear and concise. And the court upheld that limited scope because his agreement was 2 pages, although the court did sanction him because he had in there a violation of 1.8 where he said, look, and you're not going to sue me for malpractice for any of these limitations.
Right.
Right.
I think a pretty common fact pattern for at least general practitioners would be you have a personal injury case. You've been, your retainer agreement says you were injured on August 25th, 2013 in an automobile accident, and you're paying a 33% agreement, and you've got costs. Is that sufficient limitation, or do we need to now start writing more? Is the rule changing such that we have to change the standard retainer agreement that says you got hurt in a car accident and you're hiring us to sue someone?
No, because I think you're representing them in their entirety in that matter.
Although I guess if there were potentially a workers' comp
claim.
what about a Social Security that might come out of the disability? Is that...
Well, it's a good idea in that what we're talking about in that scope of representation section, that we make it really clear that we're not representing them on other claims, and that they may want to, check with another lawyer to see if they have any Social Security claims or any claims, workers' comp that we wouldn't cover or that our firm wouldn't cover.
Thank you.
Thank you.
Yeah.
We have one right over here.
Oh, no.
She was next.
Yes. Waiting patiently.
Thank you. I have a new client coming in this afternoon in a divorce matter. She's pro se, her husband is pro se. They went before the commissioner, and everything is done except the forms. She called me and said the commissioner ordered us each to pay $500, go to an attorney, have the financials done, the findings of fact done, and the marital settlement agreement, and come back with those at the next court hearing.
Yep, that's limited scope. And so right now, the way 1.2C reads is that you just have to get informed consent. After January 1st, when the rule changes, that informed consent needs to be in writing. One of the other things, if you are going to get those informed consents in writing, make sure the client signs it, because even though it's not required in that part of the rule, another section of the rule says that there is a presumption created if the client signs that informed consent.
So Aviva, might our questioner be able to avail herself of a very simple shorthand way of getting past reasonableness and informed consent by saying, I'm acting pursuant to the court order against you to behave in this fashion? I think certainly in any memorandum that was prepared about this, I would use that express language, that the court, you're acting according to the order of the court to prepare these documents.
Is it a written order?
I haven't.
You haven't seen it yet, that's right. And even if it isn't written, it'd probably be a good idea to put in there that the client's told you that.
Right,
You
because otherwise you'd need the letter that Aviva described, the engagement letter with, I'm not going to evaluate your property in Taos, and I'm not going to look at your stocks and so forth.
And that's what I'm concerned of also, because if I evaluate or advise on anything else that I need to, then, I'm outside of the scope.
Right, but are you going to look at the agreement itself, or just do the?
I'm going to have to
Right.
speak to both of them about the agreement and then draft it for them.
Wait, they're both
Both?
engaging you?
She says the commissioner ordered my husband to give me $500 and me to put in $500 and for myself to find an attorney to draft the documents for me.
So,
I'll talk to you after this.
Okay.
I'm thinking that, I would be concerned. I've seen a number of judges and court commissioners. You realize, folks, that one of the reasons why limited scope representation is so important right now is because of the huge numbers of people going through divorce processes without any representation at all. In Milwaukee County, we're looking at something pushing 80% of all cases have one or both parties, unrepresented. And what I've heard judges and court commissioners just worry a lot about is the client who looks like they're receiving an extremely unfair or imbalanced agreement, that they are waiving support, they're taking less in property, etc. And so I've sat in the courtroom waiting for my turn, hearing judges struggle with this sort of thing. And so I guess I'd be quite concerned that perhaps there's also a perceived either power imbalance or very disparate allocations of property or income in that agreement. And so watch that very closely, because you may need to be very sure to advise this woman that as to the appropriateness of the underlying agreement itself. Because you can't be just a mere scrivener
Right.
in that situation.
And the other part is that you have a third-party payer.
That's another problem.
Yeah, yeah, we'll talk afterwards. I have a meeting.
Did we have another question?
Yeah, and there's a list of them on the web as
Okay.
well.
Oh, my gosh.
Hand up over here.
This gentleman here?
No, sorry.
Thank you. You already answered some of this. My question was going to be, to what extent does the written information on which the client consents to whatever limited scope you're engaging in have to be signed by the client? And what I'm thinking about is those paid-for initial consultations and, okay, I just need somebody to look at this and tell me if it's okay. I love questions like that. But, you know, I mean, where you're sitting down for maybe one meeting and that's all you're doing, and now, I mean, hitherto, for the under $1,000 sort of service, like a long consultation where I'm going to charge for it or something like that, you know, I might send the client an email or something setting this out, but I don't necessarily have them sign something. Are you telling me that now, especially after January 1st, I should have them sign it?
Well, and I don't know why the rule is drafted like this. The rule says the consent has to be, the informed consent has to be in writing. But later in the rule, it says that there's a presumption, and it's the new numbering will be 1.2C2, that if the client gives informed consent in writing signed by the client, there will be a presumption, and there's two parts to it, that the representation is limited to the services described, and that the lawyer will not represent the client generally in other matters. But the problem is, is it a rebuttable presumption, irrebuttable presumption, and what does it mean if your client's, and how does that differ from just the consent? And so I'm not quite sure if there was a drafting error in that it should have been informed consent signed by the client at the outset, but certainly in that instance, you just don't have the presumption. If you don't get the signed by the client, there's no presumption. And we don't know what that means yet. And in fact, when I asked Judge Colas, because he was on the subcommittee, and he couldn't recall that was really discussed.
Just have a couple. I'm sorry, Dan. We're going to run up on time here, but some web questions. One is, can the written informed consent for limited scope be accomplished via email?
Yes, writing is defined in 1.0Q, I think. I should know that number. And it's a great definition because it includes audio, it includes video, it includes electronic. So it's handwriting, typewriting, printing, photostatting, photography, audio, video, recording, and email.
Okay. And then another question, very, very broad, very general. What is the definition of limited scope engagement? Do we have a definition?
There is no definition, and one of the things that Judge Colas and I talked about was, what does that mean? And it appears that if it's anything short of the entire matter, so if that means the factual situation, anything short of representing everything arising out of that matter may in fact be limited scope.
Okay. Another one. It was brought up that a lawyer was hired to review an agreement a mediator drafted. Mm-hmm. I was provided a memo from Tim Pierce about mediators not being allowed to draft the actual agreement to be signed and filed with the court. Mm-hmm. Does anyone have experience and insight regarding mediators drafting mediated agreements, specifically when asked to mediate between two pro se parties? This is likely most common in divorces.
It is most common in divorces, and the Tim Pierce memo is well known to me. Basically, the content is that if you are a lawyer mediator and you achieve an agreement, you may not ethically draft the settlement agreement. The reason underscoring this is because, as a lawyer in drafting, you are presumed to have a client to represent, and if you're drafting, you must be representing one of the clients, and you have a conflict flowing out of Rule 2.4 that sets up the propriety of lawyer mediation in the first place. Keep in mind that in the middle 70s, it wasn't even ethical for lawyers to mediate. We've passed that hurdle, but a part of actually the considerations and deliberations of the judicial commission, the committee that drafted the limited scope rule, was whether or not they would look to try to create some kind of exception to allow lawyer mediators to actually draft marital settlement agreements. I am a proponent of the concept that the terms of a mediation settlement in writing is also something that can be mediated, that we can take a marital settlement agreement paragraph by paragraph and mediate the outcome and provide information to clients about the impact of those agreements. But right now, under the existing rules that we have, this is simply not possible ethically. There's a new committee, a new task force. This is the PPAC committee.
Right, PPAC.
It didn't come to me at first. And
Planning and Policy Advisory Committee.
Right. So the PPAC has a special task force being chaired by Judge Mike Dwyer out of Milwaukee County looking at this particular topic. The sad reality of that is that if you could turn your law license on or off, if you could turn it off for a minute, there's no problem with lay mediators or mental health mediators or financial mediators. Anyone who's not a lawyer as a mediator can write up the agreement.
We have another question from the web, and this shifts gears quite significantly, but here we go. Since wills only speak on death, isn't there a real risk of breaching client confidentiality in filing a client's will unless you in fact know it is the last will of the deceased client? Anybody want to tackle that one?
If it's required by statute, that's what your ethical obligation is, and it's higher and mightier than, your Chapter 20 requires that you act in compliance with the law.
Right.
Okay. A little bit of time left, maybe 10 minutes. I want to touch a little bit on AVO reviews, Aviva. This came up at our summer seminar, a lawyer talking about seeing a negative review of himself on AVO, AVVO. What are the implications of this? And I guess the question he had was, should I respond, and if so, how?
So you can respond, but you cannot in that response disclose any information relating to the representation of the client. So there's a Pennsylvania ethics opinion that came down just this year. It has sample language in it. It's okay, but all that language says is the lawyer's duty to keep client confidences has few exceptions. And in an abundance of caution, I do not feel at liberty to respond in a point-by-point fashion. Suffice it to say, I do not believe that the post represents a fair and accurate picture of the events. Here's the reasons why you can't do it. There was just a recent disciplinary case, disciplinary proceedings against Peter Thompson. In that instance, even though it was an ineffective assistance of counsel case, the court said very clearly, in a quote, defending one's professional reputation is not among the permitted exceptions to the confidentiality rule. And oftentimes, lawyers who want to defend themselves to those online criticisms will look at 1.6c4, which is the exception that says you can establish a claim or defense against, if in a controversy against the lawyer and the client. And they were saying, well, this is a controversy. He attacked me online, right? But it's clear that that's not a controversy. A controversy is either a civil, criminal, or disciplinary action. So you can't bring that exception in C4 to bear and say, look, I can respond online.
Aviva,
Yeah.
could you, if the matter involved litigation and there was material that was in the record, the public record, could you repeat what was in the record?
No. So this is a really a misconception. 1.6 is so broad, it covers all information relating to the representation of the client, even client identity, and even information that's in the public record. There is absolutely no exception for information that's generally known or in the public record. And the way we know that is if you look at 1.9c, and it says you can use information to the disadvantage of the client if it's generally known. So they have that generally known exception for using information for a former client. But even the confidentiality rule in 1.9c2 for former clients, it sends you back to 1.6. So you owe the exact same confidentiality to your former clients as you do to your current clients. So, yeah. So even if it's in the public record, in fact, there's a disciplinary case, Harman, Harman, where the lawyer disclosed information that was in a deposition that was in the public record, and the lawyer was disciplined for that.
Okay. Any other questions, comments?
Good question. Thanks for asking.
We were going to take up fees on this panel too, but we're running short of time, and I want to cover one other thing here. So I'm going to ask Katya in the second panel to take up fees and fee disputes and how to handle those, if you're all okay with that. But before we finish up on this panel, Kevin, I want to bring something up to you. I read with interest your column in this month's issue of Wisconsin Lawyer. You talked about going to Seattle and seeing a friend who is a sailboater, and he was describing to you how he looks ahead to see the choppy waters and anticipates so that he gets back to shore safely. And so, and then you talked a little bit about your takeaway from that as it relates to lawyers and how lawyers sometimes are not good at looking ahead. Tell me your takeaway on that.
Well, I think my first takeaway, what I put in the column too, is it's kind of annoying to talking to your retired friends who are blissfully happy. And in fact, my friend had the temerity to tell me that he needed a watch that told him what day of the week it was, because every day seemed like a Saturday. So, but
you're gonna go back and visit him?
Yeah. It was, when he said it, I thought, boy, that really does apply to the law. And again, we have two very young new associates in our office who are outstanding, but it's really interesting to watch, young lawyers and realize that maybe we do learn things the more we've been in the practice. And one of the things is, not looking at everything through a keyhole and trying to think, the big picture on client matters. And when I was thinking about it, I thought, this doesn't just apply to new lawyers. I deal with a lot. We do in our office both transactional and litigation. But if I'm dealing with a transactional matter and negotiating a contract, I'm often dealing with some very good lawyers on the other side that don't litigate. If the contract ends up going into litigation, they pass it off to their litigation team. And sometimes I feel like that they miss things, or they don't think ahead, or they don't advise their clients on some very key issues because they just have a very limited role in the in the matter. And this kind of goes to the limited scope representation we were talking about before. So I think one of the best things we can do as lawyers, whether we're general practitioners or we are specialists, is to try to look at the big picture with clients and advise them that, yeah, you may win on this matter, but is that going to put you ahead in the long run? And when I'm advising the young lawyers, it's like, you tell the client, you give them advice, you recommend what to do, but part of the recommendation is not just on this, but how is this going to affect, if it's a family business, for example, how is it going to affect your family relationships? How is it going to affect the business going forward? It might cost you money in the long run, even though you win this dispute with your brother over which one of you is president of the organization. So I really think that that's important, and I think that's something that is often missing in our practice.
Well, it's 10:15. I don't see any other web questions. Any questions in the room? Comments? Disagreements? Observations? Okay. All right. Well, listen, I want to thank Aviva Kaiser, Diane Diel, and Kevin Palmersheim. Please give them a round of applause. They've been great. We will adjourn for about 15 minutes, let you stretch your legs a little bit, and we will be back at 10:30 with the second panel. Thank you.
Welcome back. We are on the second half of our late fall seminar. We have a new panel up here. I'm Katya Kunska. I'm with Wisconsin Lawyers Mutual Insurance Company. We are talking to you today about stuff you asked us to talk about. So it may seem as though we're jumping around from topic to topic, but that's because you wanted it that way. So we are letting you define good customer service. So our panel now for this second half, to my immediate right is Richard Cayo, who's president of the Milwaukee law firm of Holling and Cayo. He's the guy we send people to when they need to be represented for discipline matters. He's been advising lawyers and law firms on ethics and malpractice issues, testifies as an expert on professional responsibility. He talks about it, he writes about it, he thinks about it. He's on the Milwaukee Bar Association Board of Directors, was on the State Bar Board of Governors, and has served on State Bar and Supreme Court committees to review the model rules of professional responsibility. Welcome. To his right is Kevin Klein, who you will recall is our recent past president of the State Bar of Wisconsin. He's a sole practitioner. He does lots of stuff, including litigation. He was the president of the Taylor County Bar Association. He was on the board of governors for the State Bar. He's been on a bunch of State Bar committees and projects. He volunteers in his community. He's on the Law Foundation Fellows, and we're really pleased you're here.
Thank you.
To his right is Tison Rhine, and Tison, forgive me. Eventually this will stop. Tison is the new Norino. So he is the State Bar's Practice 411 Law Office Management Assistance Program Manager. It's a lot of words. He's the guy you call when you need help in figuring out office systems, and particularly in technology. Tison's a lawyer. He got his JD from the University of Minnesota. He was general counsel for an Indiana-based energy company. He's practiced in small firm and clinical settings. He has a bachelor's degree in engineering science, which has just got to be helpful. And to Tison's right is Kathleen Dettmann, and Kathleen was mentioned when Kevin Palmersheim was up here. Kathleen is a senior associate at Haley Palmersheim. She also concentrates her practice on business litigation like Kevin does, but she likes to work closely with family farms. Because they have not only estate planning issues, not only the business issues with generations and who's on it and who's off it and who wants to do what, but the estate planning part and succession planning, not just for farms but for businesses and for individuals. She earned her bachelor's in political science from the University of Wisconsin, graduated from UW Law School. She did very well in law school. And before she went there, she worked as a lobbyist and a public policy analyst. So we have a lot of expertise up here, and we have a diverse group of topics to talk about. And Tom has some questions on the web before we even started, so why don't we start with that?
Yeah, we have a couple of leftovers, Katya, from limited scope discussion, and so I'll throw these out there if the panel wants to take them on. Otherwise, maybe they could be directed by email to Diane or Aviva. But one question was this: we are creating very long engagement letters, in essence very complicated contracts. We tell clients not to sign any contract without our advice and review, and yet we're asking them to accept and sign a complicated contract whereby we, by definition, cannot advise them regarding their signing. How can the rules assume that there is informed consent when you are giving a potential client signing a 6-page agreement with 32 subpoints which they sign without understanding what is in it?
Is that a commentary or a question?
Yes, it does sound like an editorial of sorts, but...
Anybody want to take that up?
Well, I can comment on it briefly. I'm a firm believer that less is better. I think there's also the argument that if you have such length to the document, you're going to face the argument in the end that, well, you didn't say this, and you meant to say it if you said all of these other things, plus flip that coin over. You excluded something, you must have excluded it purposely. So I think you want to tailor those documents to the type of practice you have, rather than some format, rather than some detail. the type of work you do and what you see over a period of time that clients are interested in. So, you know, I'm a believer that less is better. And the other thing that reads right into that question is you have to understand that at the beginning of representations, and a client gets this document, do they even really read it? We're drafting it as attorneys. We're understanding the terms. We're saying, well, we better put this in or we better exclude that. But what do they understand about it? And I think what you have to do as a follow-up is talk to them about the engagement letter. Explain it to them after they've signed it.
Richard.
Well, bearing in mind I represent lawyers, I would say I'd forget all the hand-wringing about what the clients understand. If we need a reference in there to conflicts of interest, and if they have, and we have a discussion with them that's frank, they can go to see another lawyer if they need help signing that. We should have those signed, and if tailoring them too much means you're not going to use them, you're better off using a boilerplate document that has 6 pages than not at all.
Okay. 2 more here, Cayo. One is also a limited scope question. What is the purpose of this rule on limited scope informed consent disclosure? What are you trying to accomplish, and what is the cost to spend the considerable time just to imagine all the potential risks, and who is going to pay for that time and writing of the informed consent? It sounds like you are trying to kill an ant with a sledgehammer. Clients are not going to want to pay for all this time.
Sure, you have a response?
It shouldn't take that much time. I mean, for limited scope, and this rule, unlike most, really has a benefit to lawyers. Most changes in the rules over the years are just sort of tighten the noose around lawyers' necks in relation to their clients. But you know, if we're handling a real estate transaction but we're not going to give tax advice, it bears saying. I mean, there are some things that are so inextricably bound that you can't say, I'm going to give you estate planning advice but not tax advice. So you can't disavow that. But in other respects, anything confirming the limitations on the scope of your work are helpful to lawyers. Because anything outside that is going to be, the client is going to later on have a right to say, I thought they were going to take care of that and didn't.
Okay, and then one more. We prepare deeds for title companies. Do we need a limited scope agreement from each seller? Maybe a Tim Pierce question.
Yeah.
I mean, some things are self-evident. If you confirm I'm going to draft a deed for you for the sum of $100, you know, it may be self-evident that that's all you're doing, but it might bear saying, and only that, in connection with this work I'm doing.
I'm not your lawyer. I'm doing this deed.
Okay, that's it for now.
Okay.
You know what? I think that question asks a different question. You're not certainly not representing both of those, the buyer and seller. You want to select one of the two, proclaim that you're representing that person in the preparation of the deed and not the other, without regard to where the money comes from.
Okay. All right. One of the topics that was requested for this program today was law firm structure, particularly with regard to solo practitioners and small firm practitioners, and I've asked Kevin to start with that.
Thank you. I've split this up into a couple of categories. The first thing may seem obvious or evident, but it's really the physical structure of how an office is operated. One of the key things, and of course you heard a lot about it earlier, is confidentiality. I don't know how all of your offices are set up, but I have been in a number of offices where it appears to me there's no confidentiality at all, where there's long open counters for the general public to come in, where there's a bank of secretaries, paralegals, whatever, behind that counter, answering the phone, calendar things, speaking out loud. Anyone that walks in that office can hear what's happening and who's being spoken about. Behind that area, a number of doorways to attorney offices where attorneys are speaking to clients. They may have the doors open. You may not be able to hear what's going on, but you can see who's there. And this may be especially significant in smaller communities where people know each other. So again, it may seem obvious, but think about how your office is set up and what things potential individuals can see or hear if they're coming in. Of course, another physical aspect is client service. Everyone thinks about that differently. It depends on the type of practice you have, but your office setup has to be such that you can provide clients with the service that they need, because if they don't feel that they're getting that service, there's going to be a complaint or a problem later. Necessary equipment. Again, people practice very differently. Some people no longer have fax machines. Some people only have fax machines and don't have email, believe it or not. You have to decide for your practice what type of equipment is necessary to provide that client service. And then breaking it right down, even if you have a client in your office, what other things are in the office that you may or may not want them to see. So think through those things ahead of time. Don't just take them for granted. The second category, as far as office structure, is really the work that you provide. You have to decide in your office structure who provides what service to the client. There are some attorneys that always do their own scheduling. Others will leave that to a staff person. So that's one thing, is who addresses what work, who obtains the mail, who meters it in, who provides the attachment to the files, and who is monitoring that process all the way through to make sure that nothing is slipping through the cracks and that the clients are receiving the service. One of the things that is of particular concern to clients is the terminology surrounding paralegal. There are a lot of law firms out there that will have a staff person that has been there 6 months, and that person will be termed a paralegal. You can think what you want about that, but it spills down the road as to, is that person providing any service to the client? Is there a billing amount for that person? You don't want to be running afoul of someone practicing law that shouldn't be, or even someone providing what we may think is simple service when they're not competent to do so. So one of the things, again, with how the work is presented is who controls it: attorney, staff, paralegal. That ties into billing, which I know is a separate subject here, but who takes care of deciding what the client will be billed? That may have to do with software that you use. It may have to do with how often you bill. But your law office structure has to address who keeps track of that time and what is done to make sure that it's fair to you as a business person, but also fair to the client in terms of the billing amount and the service provided. Separating that out then, there are various things that the client sees when they come into your office as you do your work. You have to separate that out from what is behind the scenes and what the client doesn't see. How you manage your files, how you bill those files internally, how you take care of the financial filings that you have to do to stay in business, what you do in terms of library, and how much money you're going to spend on that. And tying all of that together, I think the big thing for all of us as attorneys and business people is, what is your plan? What is your plan? Do you just approach each day and see what happens? Or do you have systems in place and a plan as to how you're going to have the physical setup, what your people are going to do, and how you're going to divide out those behind-the-scene things? And for the most part, if you follow your plan, you'll run into less problems. And of course, you can adjust that plan as you go, and you experience all the little pitfalls that we all do.
And speaking of those little pitfalls and when your planning goes awry, another topic we were asked to address, and I'm going to start with Richard on this one, is so what does get lawyers into trouble? Mostly.
Well, let me count the ways. I could tell you, I started doing this when I first got into private practice a long while ago, and I now have 3 lawyers in my office doing mostly lawyer discipline type work. And by volume, probably what gets lawyers in trouble most is neglect, failure to communicate. But at the heart of all that, if you want to get down to a level where you could do something about it, it's case selection. I can't tell you how many lawyers I've represented who come in with a client who's complained bitterly about this or that, who says, I could see it coming. And to which we all can reply, well, then why didn't you do something to avoid it? I heard Mr. Palmersheim say, refer to the 80-20 rule, and it's true. I mean, we know lawyers are credited with the litigiousness that seems to be part of our culture, but it's not the lawyers, it's the clients. I mean, the lawyer wants to do a workmanlike job and get paid for it. The client wants nothing more than to win. And maybe more than win. They want to scorch the earth, and so they call upon their lawyers to do what's most of what we do. We don't just dream up. So I tell my clients who are lawyers, fire those clients. It's very hard to exercise case selection in the first instance because anybody can be charming and reasonable for a half an hour. It's sometime thereafter that you come to learn that they want you to kill their adversaries and not just defeat them. And there's a rule, SCR 20:1.16. Which has to do with withdrawal from representation. There's a whole host of reasons why you have to withdraw, and a number where permitting you to withdraw, including an instance where you can withdraw without meaningful harm to the client, so that if time is permitting, you can withdraw from cases even without some cause to do so. One of the stated causes is failure to be paid. I see lawyers all the time feeling as though, and including in my own firm, bless their hearts, feeling conscripted to work for clients who haven't kept up their side of the bargain. And that fosters, number one, if they don't pay, they become enfranchised in having you do everything conceivable on their behalf. Number two, when their bill gets to be $50,000, suddenly you've turned into one of their problems about which they're likely to complain. And three, you're not going to do as good a work for people who aren't paying you. And in fact, in some respects, you can't. So I tell people make sure they withdraw when they're not being paid. And just as one little practice tip, there's a provision in the rule that says you can withdraw for a failure of the client to fulfill an obligation to you, so long as they've been forewarned that that's going to be a consequence of their failure to pay. And there's no reason not to do that right away in writing in your engagement letter, to say you're agreeing to pay me X dollars per hour within 30 days of the rendition of a bill and so on, and in the event you don't, we're agreed that'll be grounds for me to withdraw. So that's a fraction of what I could say about what gets lawyers in trouble.
All right. Anybody on the panel want to jump into that before we move on to another topic?
I would just briefly say, and to piggyback a little bit on what Diane Diel had said on the earlier panel, is that you really have to trust your instincts when it comes to taking on clients and cases. And, in our firm, we recently hired 2 young lawyers and trying to impart upon them that every call that comes in, every person that comes in the door does not have to become your client. And it runs against our instincts because a lot of us become lawyers because we want to help people. And so when someone has a problem and we have the tools to help solve it, we want to jump in and do that. But I think for most of us, too, we tend to be pretty good observers of people and understanding what motivates people. And a lot of us have good instincts in that first conversation as to whether or not someone's going to be difficult. And it seems to me that in the times where I have gotten caught up in that, taken on a case against my better instincts, that I really did know at the beginning that this was going to be a problem. And as Kevin Palmersheim had said earlier too, really more business is not always the best thing. It's good business versus just more. So I think the more that you can be discriminating about the clients that you take on and really learning to say no at the beginning rather than in the middle when you're owed money and everyone's angry, it can really forestall a lot of these problems.
If you do have staff, I think it's important to listen to their instincts as well, because people will present their best self to the lawyer and can treat the staff like dirt, and your staff needs to know that's really valuable information. Tison.
I'd just like to add that when it comes to the deadline and communication issues, you already have the tools that you need to help you with that built into your practice management software or even your email software. The trick is just making it a habit. Like, you need to set those reminders. You need to use your calendar and set alarms for yourself. And a good way I like to do it is when I get an email from a client, or when I was practicing, I would set the alarm for a response immediately when I got that email. And if you just get into the habit of doing that, that's going to eliminate a lot of the communication issues.
Yes, as long as you think before you hit reply.
Right.
Sally Anderson, when we talk about claims at WILMIC, it's like, these email and these immediate response devices let you get your mistakes out the door at the speed of light.
Catch up. I may, apropos of talking with your staff, a friend of mine has a company in Palo Alto, and they when they're interviewing people, they have them come onto the campus by means of this shuttle, and they consult the bus driver about the way the person treated them. And in fact, I think, although he didn't confess this, that it's monitored, that they can see how this person reacted with the bus driver coming over to see to get some insight into what sort of a person they are. Clever.
Not that I have great experience in dating, but I've heard that watching how somebody treats like a wait staff person is very telling of their actual and true personality. All right, let's move on, Kathleen, to social media, which I think is called social, not professional. So I have a little bit of struggle with that, and I'm very sympathetic to Diane's comment about kicking and screaming in all the different ways we have to be electronically available.
Yeah, well, I think that's pretty apropos, because I believe that social media is sort of the next frontier where people are going to be dragged kicking and screaming no matter what your age or affiliation. But at the same time, I think the opportunities here are really limitless in terms of what you can do with social media. It's the great equalizer in terms of what people can do with limited advertising budgets, especially for small and solo firms. So to the extent that you can get yourself, if you're already there, great. If you're not there, there are all kinds of tools and platforms for you to get yourself there. So as a lot of you probably know already, there's a host of different platforms for social media. I mean, the primary ones everyone knows about: Facebook, LinkedIn, Twitter, blogs, Google+, and of course your own website. And the key to creating a good social media presence, which I think helps you both in terms of attracting the right kinds of clients and also in bolstering your own professional reputation, because there are certain lawyers in all of our communities who are really active bloggers, or they might be active on Facebook or Twitter, and it definitely helps raise their estimation, raise the way people view them in the community, which I think helps all of us in terms of lawyer-to-lawyer referrals for quality clients. So Facebook in recent years has become less of just a personal website for social media and more about professionals. So every professional, every firm or individual can create a Facebook profile for your firm. You can do the same thing with LinkedIn, which is essentially just an online resume. Although the connectivity you can get among various professionals is pretty amazing when you actually think about it. I read something that if 20 people have 100 different contacts, I mean, you're talking about thousands and thousands of potential links to whether it's clients or even other types of lawyers that are working in other fields that can help us all build our practices. So then Twitter, which, as everyone knows, it's the 140 character tweets. I frankly am always still confused at all of the ats and mentions and hashtags and all the things that go along with it. And then blogs, which I think are, most of you, if you have websites, can have a blog on your website that we try in our own firm, as Kevin is always reminding me, to write blog posts. They don't have to be long, they don't have to be complicated, they don't have to take a lot of time. But I think integrating all of these different platforms is the key. So in terms of all of these different types of social media, the main three factors I think you have to remember are connectivity. So you're talking about having all of these platforms, and you can cherry pick content from one to the other and use them to cross-link. And all of this cross-pollination helps raise your website, your profiles, and everything else when it comes to Google's searching algorithms. So you don't have to create unique content for your Facebook page versus your Twitter feed or your blog. You can cross-link everything. You can do what the fancy term is called newsjacking. So there's a great Supreme Court opinion. There's another great article that someone else wrote. You should link to that and say your own comment about that. You don't always have to spend a lot of time coming up with unique and interesting things to talk about, because as we all know, a lot of us don't have that much time. So connecting things, I think, is really the key when it comes to creating a multi-platform social media presence. The two other factors I'm going to touch on briefly are, especially if there's more than one person in your firm that's going to be working on social media or managing it, you need a social media policy. So, and this really dovetails with the third factor, which is dealing with the ethical hazards and having a social media presence. So your social media policy is going to need to really tread that fine line between creating a very detailed and formulaic policy, like an employee handbook that we all can't help ourselves from doing, and recognizing the fact that social media really, the key to it is speed, spontaneity, and creativity. So if you have a whole host of rules that people have to follow before they can jump into the social media world, you're really going to hamstring yourself in terms of having an effective presence. So the policy, I think, is going to be really important, particularly, like I said, if there's going to be more than one person in your office dealing with it. Then in terms of the ethical issues, you're going to need to deal with advertising rules. All of those are going to be a really big deal in terms of your social media presence, especially when it comes to messaging and real-time connection with potential clients. And certainly how you present yourself, not using the terms like specialist and things like that can get everyone in trouble. And confidentiality is the other one that frankly I see all the time in my own Facebook feed among my lawyer friends, is talking about your cases on social media. As Katya was pointing out, you have to have a good dividing line for yourself and any of your staff between your professional presence and your personal presence. So I think it's a good rule of thumb to say that even on your personal page, if you have an affiliation with your firm saying where you work or what you do, that you still have to treat that as if it's a professional Facebook page. And when it comes to talking about clients, no matter how vague or veiled you make it, given how far these things can stretch, someone can conceivably understand what you're talking about or who you're talking about. So I think, frankly, it's a good idea to just not address those things at all on your social media page. And the one other thing I wanted to say about a policy is that I think supervision is key, especially when you're talking about, and this really can't be about age, because younger people in your office might have more understanding of social media and how it works, but they also may not understand how to effectively present themselves to clients and to the world in a professional manner. Older people in your office might just need a little bit more supervision in terms of what things are appropriate to say on a social media platform. So I think some supervision, and then you need to have some things that will require advance permission before you do. And the two things that I would always recommend people do is, before responding to a negative comment on social media, which came up on the last panel, you really need to bounce that off people and think about it before you engage. And the other one I would say would be recommending colleagues. So on Avo and some of these other sites, you can recommend colleagues, and I think, especially if there are other people in your firm, you're going to want to have a unified policy on whether or not you can do that and what the parameters are for doing that. But just to wrap it up, the easiest thing you can do really is on your own websites, provided that you have them, which all of you should, is start with a really basic blog. Your website will be able to do that, and then it only has to be a few paragraphs. It can be about current issues, something you saw in the news, a new case that came out from the Court of Appeals of the Supreme Court. And once you have that seed and that kernel, you can create a Facebook page, a LinkedIn page, or a Twitter feed that just links to that and cross-pollinates it. So all of those things are really just going to raise your searchability for Google, and that's really what everyone needs for their online marketing.
Thanks. I'm holding myself back from going onto the internet now and removing my profile photo from my Facebook page that has me standing in a swimsuit on a beach in Hawaii under the tidal wave evacuation route sign.
Why does it not surprise me?
I thought the sign was funny. I didn't think real hard about the swimsuit, and now I was like, oh.
Executive Director of Wisconsin Lawyers Mutual Insurance Company.
Gosh, remember that do as I say and not as I do thing that came up with Kevin? Yeah. Tison, do you have any samples or access to samples for social media policy for me?
I don't have any comments on the policies, but I did want to comment on, Kathleen mentioned that integration is key. But it can be pretty cumbersome when you have LinkedIn, Facebook, Twitter, all these things going on at once to keep track of it all and to have content, because you really want a steady stream of content in order to be most effective. And there are some applications out there that can really help with that. One I like is called Hootsuite. I think it's Hoot Suite. And what it does is it allows you to have LinkedIn pages, multiple Twitter accounts, multiple Facebook accounts, all on the same screen. And you can schedule posts for later in the day. So because you want a steady stream, but you don't want to, you have time to do this now, so you're going to post 4 things. So this allows you to schedule it, sparse it out throughout the day, or even over weeks if you don't want to post all the time. And that's just a really simple way to manage it all together. Another thing that you could use is called If This Then That, IFTTT. It's an app that you can get on your phone. I think you can use it online too. But it has many functions, but for social media, you can tell it to, every time you post on Facebook, automatically post on Twitter, or vice versa, or that kind of thing. So that's really helpful. I would also like to give a slight warning about the way you use Facebook and Twitter. There's a little bit of a backlash from certain people who view these social media things as just social. They don't like to see advertisements or any kind of business presence come up in their feeds. And if they see one, they may unfriend you or kind of mute you. So the way I think to be most effective is start a blog and have your tweets or your posts be links to your blog or links to articles or other interesting news happenings that you think your clients will actually care about. And that's a good way to remind them that you're out there, keep your name out there, but not really bother them in the social media space. And with that, you should follow Practice 411 at Practice 411.
All right, Hootsuite and If This Then That. Good tips. Richard, any problems?
Sure. I liked what Kathleen had to say, and I think in general a policy to observe about treating any of these posts as if they're marketing for advertising under the Supreme Court rules will help you protect yourself, because eventually they may be measured by that criteria. And with respect to confidentiality, Kathleen mentioned drawing these lines, and one of the lines that lawyers typically fail to appreciate is that SCR 20:1.6 makes confidential all the information gained in the course of the attorney-client relationship and preserves that even with respect to former clients. And it is not fair game to broadcast information about clients just because it's available, just because it's public. I mean, I represent lawyers. I've had lawyers, I've had successful representation of lawyers in front of the Supreme Court who don't want me mentioning their names in any connection, least of all by means of social media, even though I might like to because I want to foster my own reputation. And I think they have a right to have me refrain from doing that unless it's necessary. The other thing that I think is to be forewarned about is the use of social media that creates unintentional attorney-client relationships. And this used to be sort of just apocryphal talk about cocktail party conversations that go awry. But with the advent of our websites, all of which are designed to bring business in and to get people to contact us, the likelihood of creating unintended relationships is more prominent. For example, if someone responds to an invitation to send them an email and sends us a bunch of information, they probably do that with an expectation that's going to be treated as confidential, and under many circumstances, it's not. And so in order to avoid obligations to ourselves that we don't intend, at the very least, at that point in the website where we invite them to contact us by means of an email to have a disclaimer that says this does not create an attorney-client relationship, and not everything you say to us in responding to this invitation can be guaranteed to be confidential. And to use a click-through, you'll be able to, Tison, you can correct me here. I'm too analog to have the right expression, but have them actually have to click through an acceptance of that condition as a means of getting an email out to us. You follow me?
I think so, yeah.
There's a series of disclaimers that are available through the State Bar Ethics hotline. Tim Pierce has composed a number of these disclaimers that are very effective, I think.
Kevin, you want to chime in on this subject, or would you like to move on to difficult clients, or back to difficult clients?
Let's move back to.
Back to difficult clients. All right, any questions about social media before we move on? All right, moving on to difficult clients, because I bet you've all had one.
Well, and of course, thinking through this subject, I have a few of those little war stories that I can tell, but you all do, and maybe I'll tell those anyway. But I think we back up to the get-go to talk about dealing with difficult clients. You've already heard the discussion about when the bells and whistles should go off, should you take on this person as a client. So we've had that discussion. Be aware of that. We've also talked about engagement letters and those things that you may put in there to help you deal with the difficult clients as you go forward. But I think it really takes being objective. That's the one thing that overrides all of this. I tell clients all the time, you're not going to know what perhaps your opponent has told their attorney. You're not going to know what that attorney has responded. And if you flip that coin over, do we all believe that our clients tell us everything when they speak with us? Of course they don't. We want to be social. We want to be looked on as intelligent. We want to please the client. So we tend to accept that information as all of the information. And it's very tempting to say, well, you know, this is just a slam dunk issue and here's what's going to happen. That's the biggest mistake that can be made. You have to be objective and say, we know that there will be counter arguments to this. We can't pre-plan steps 2, 3, and 4 until we know how the alternatives have shaken out on step 1. And so all of those initial things help you deal with the difficult client later, because you're setting the stage to be able to say, remember we talked about this. And of course, at various points in the procedure, you can confirm your conversations with emails or with letters.
Please do, for purposes of defending the malpractice claim.
Exactly. You know, some of the particular war stories, and again, I'm sure all of you have had some of these, but the one is the client at some point that insists that you be their friend. I've hired you because I want my attorney to be my friend. You know, that just strikes me as strange right from the get-go.
You have to pay extra for that, don't you?
Well, you should make them pay extra for that, but if you think about all of the consequences rolling downhill from that, you would stop and say, wait a minute, do I really need to represent this client? Now, maybe you're in the middle of a representation and the client's been fine, but you have to have a very clear discussion at that point. No, I'm not your friend, I'm your attorney. Here's what goes along with that, and can we move forward? And if for some reason you get the vibe that you can't, then maybe we should have a withdrawal motion. So that's one. Perhaps the one that's talked about the most is the client that comes in and says, I want you to be the nastiest advocate for me that you can be. That's always a warning sign for me. You know, we do have duties to clients, but just because we can do very many things doesn't mean we should. And we also have an obligation to the tribunal. So when you hear that, I think it's necessary to talk to the client about how much time and effort do you want to put in, how much is this going to cost you, what are the best alternatives, and try to get the client to see the end result and the bottom line and say, now let's work backwards from there to determine what things we really should do or shouldn't do. So that's another example. The client that comes in and says, you know, you've been referred to me, I hear you're a really great attorney, and since you'll be my fourth attorney on this case, I want to make sure we get off on the right step. Again, a bells and whistles situation, there's a reason that that client is on their fourth attorney. Maybe you're going to be able to get to the bottom of that, and maybe you're not, but you have to be aware that that creates a difficult client situation. Another one, the client that continues to repeat something that you hope you have explained and eliminated the concern that the client had. So the client says, well, I think this should come out this way, and you give them an explanation, and they even acknowledge it. They say, okay, I understand, I agree. 2 days later, they call you and they say exactly the same thing that they said in the first place. That's one of those situations where you're going to want to see a letter go out and say, I've spoken to you about this on numerous occasions, I've explained the pros and cons of this situation, and here's the objective approach to it. Because I can guarantee you, if the client has done it once or twice, they're going away from those conversations, and in their own mind, they're going to say the same things to themselves the third time, the fourth time, the fifth time.
I mean, don't you think, though, that one of the things you really need to be cautious about is not all clients understand things the same way. I mean, there's clients who can't read. There's clients for whom English is a second language. There's clients who have, you know, some impairment. In family law, it would be that whole emotional overlay where you're this whacked crazy person and you will be for the next 3 years, which we see come back in claims. Because whacked crazy people make different decisions for different reasons than more rational people. So how do you figure that out?
Well, you know, you figure it out, first of all, by your gut feeling. Second of all, by your experience in handling cases over a period of time. But perhaps the third thing, which is the best rule, is continue to have communications with your client.
Listen.
Right.
You have to listen to them and ask them, you know, tell me what you just heard. Because if they come off with something that is 4% of what you just said, then your explanation wasn't enough for that client, right?
Yeah, we have the habit of wanting to be the person that's speaking in the communications, and we should be letting them speak. I often say to clients, does what I just said to you make sense? So you're getting an answer from them one way or the other. Second, please explain to me why you feel the way you do in conjunction with what I just said to you. And again, you're making them communicate. So phone calls, emails, sitting down and having a meeting.
And you know, the antagonist, the snarling client that comes in sometimes is easier to recognize than the stealth assassin, which are friends and relatives. I mean, there are very few. I mean, two things are wrong with those clients. Number one, they are the ones that pull us out of our areas of expertise. You know, if a stranger calls me and says, "Richard, can you handle a piece of plane crash litigation or a patent application?" I'll say no. But when my Aunt B, who brings me a pecan pie every year, says, "Well, you're a lawyer, so I assume you can do anything that lawyers do," you have a tendency to not want to disappoint them and to get dragged into areas that you're not familiar with, number one. And number two, not to be able to realistically deliver disappointing news. You know, doing a workmanlike job on behalf of a personal injury client that's a stranger may not suffice for your girlfriend, or for someone to whom you feel you owe some special duty. So I always caution lawyers. Number one, that's why it's dangerous to take those cases at all, because your objectivity is kind of sacrificed in the process. But in any case, you should be careful and try to keep a business-like approach to that relationship.
Tison, we have a question that needs a microphone.
Thank you. I've had experiences where I've been appointed through the public defender's office to represent clients, say on a Chapter 55 guardianship or something like that, where, for example, the client might be elderly, suffer from dementia, and in some cases are almost nonverbal. And obviously those are the things that probably lead to the guardianship petition to begin with. But how do you recommend tailoring your communication with the client in those circumstances where you already know that there are some significant impairments?
Well, my first question back to you is, who's your actual client? If it's a guardianship, they're not a client, right? The assumption is they need somebody else to speak on their behalf.
Well, I'm not the guardian ad litem. I'm actually advocacy counsel for the client.
So they are your client?
Yes.
The person with diminished capacity is your client?
Yes.
All right. Distinguished panel, step up.
One thing that I would consider in that situation is, if your advocacy client, there should also be a guardian ad litem. All right? The guardian ad litem has an obligation to serve the person, also has an obligation to talk through the details of what that guardian ad litem may recommend. My suggestion would be that you have a joint meeting so that both of you can ask the proposed ward any questions. You can see the incompetency if it's there, or the non-responsiveness or the non-understanding, and that's going to assist you later, because the guardian ad litem is, of course, making a recommendation in the best interests of the proposed ward. The other thing, and you have to be careful what words you choose, but if this then follows through to a guardianship hearing, you always do have the opportunity to explain on the record to the court that you had this meeting. You maybe don't get into the details of the discussion, but you can make sure that the court understands that the discussions have taken place, and in that sense you protect yourself.
And the good thing for you is that at least these people come flagged with, capacity is an issue and you need to take steps to deal with that, as opposed to the whack job Aunt B who's on her third divorce. Yes.
The Supreme Court rules, there's a Supreme Court rule on the subject, particularly SCR 20:1.14, which is almost hilariously unhelpful. And what it says, I'll read it to you because you won't believe it. If I summarized it, you'd think I was misspeaking. When a client's capacity to make adequately considered decisions in connection with the representation is diminished, whether because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client relationship with the client. As if denial is the key to dealing with that trouble. And the best sense I can make of that is that we're entitled to give the client the benefit of the doubt with respect to what they say they want, and not have to, in your instance, substitute your own judgment for whether if you're representing an octogenarian who wants to buy herself a Ferrari even though she doesn't drive. Let her have it, and it really is not. It's not terribly instructive, but I think it gives you license to accept as okay what the client instructs you to do, even though you may have misgivings about the wisdom or their capacity. And secondly, the rules will permit you under those kinds of circumstances to enfranchise other professionals in your work. If they're seeing a doctor, whether for physical or mental health care problems, you can get guidance from them generally, enfranchise them in the decision making.
From a malpractice perspective, the advice we give is that you are obligated to give your client sufficient information to enable them to make the choices that belong to them. From a defending yourself against the malpractice claim when they make a choice they shouldn't have, we want you to write it down. This was my advice. That was your instruction. I'm taking your instruction. Very clear and direct language, not all lawyerly, because the last thing you need is a client saying, I got that letter, it made no sense to me, so I just stuck it in the folder with all the other letters that I didn't read that you sent me.
And the other thing, when all else fails, withdraw. I mean, you do not need to be conscripted to an impossible situation where someone's instructing you to do something that you know is out of keeping with their interests and will be the inevitable subject of criticism of you.
Other questions on this? Richard, any other extra difficult ethical issues difficult clients bring that?
Well, they don't pay you. No, not particularly.
Okay. Anybody else want to speak up? Shall we move on to? Okay. We have been assigned the topic of fees, which is always a good one. And I'm going to start with Kathleen on this. So how do you get, first of all, let's move back a little away from difficult clients right now. How do you get good clients? And we're including people who are going to pay you to work for them.
So assuming that we are to be paid.
Yeah.
Sure. Well, I think that one of the keys in all of this really just goes back to client communication and open and honest communication. So having a good relationship with the client from the start, which is frank but cordial. And this goes back to, well, I want you to be my friend. And somehow friends give great advice over cocktails, but they don't get paid for it. So I think setting those parameters at the beginning, making an understanding that these are my time is my stock in trade. So any time that I am spending with you is time that is billable, and that's an understanding from the beginning. I think, too, getting an advance on fees is a good idea for multiple reasons. One is that it at least ensures that you're going to get paid whatever was in your trust account from the beginning, but I think it creates buy-in with the client, so clients can often have these great lofty ideas about what they want to do, and cost is sort of something that comes down the road that they're not thinking about right now. But if they have to write you a decent-sized check at the beginning, it becomes very real very quickly, and I think that can reduce their, not reduce, but just change their expectations about, wow, when he said that if I litigate this to the end, it's going to cost $50,000, that is not theoretical. I mean, that could actually happen. And that, the other point is that it really just gets them used to the idea that sitting and talking to you on the phone costs money, and that your time is, like I said, what you sell. So I think between open communication and getting that initial advance, even if it's a small change, kind of really one-off sort of thing where you're drafting one agreement or reviewing one agreement and you think the fees may even be less than $1,000. I think even getting a small advance in those cases is a good idea too.
Kevin, what do you think?
Well, I agree. It falls into, again, the communications and that balance of what a client is going to expect, what you are agreeing to do for them, and what you then believe their mind may be as to what they expect on costs and fees. And it's absolutely important to get payments up front. It's absolutely important to continue to talk about costs and fees as the representation goes on, to let them know where they stand, to let them know what certain components of the case may cost. If you're going to do a certain amount of discovery, you should have a discussion with the client. It may take this amount of hours. Do you feel it's worth it? Is it necessary for our preparation? Have those discussions as you go along. That's going to keep your clients happy. And if you've gotten payments up front, you're ahead of the game.
Richard.
Well, I mean, besides keeping up, with having making sure the client keeps up so that you don't become a bigger problem than the one they consulted you about. You have to be careful about changes in your fee agreement during the course of the representation, because when you initially start out and you negotiate this agreement with them, they're not yet your client, and so there's no conflict of interest considerations. But when somewhere down the line the hourly client wants you to switch to a contingency and so on, you can be criticized for negotiating that change of that agreement without getting a conflict waiver, without having them separately represented. I know that seems overwrought, and particularly in an instance where you're doing them a favor because they can't pay hourly. You didn't take the case on a contingency at the outset and probably don't want to now, and so you're making this concession. But I've had a number of instances where the OLR has been critical of someone saying, you negotiated what in retrospect now is being alleged by the client to be an unfair advantage to yourself, cashing in on a substantial portion of the ultimate recovery, which was perhaps more imminent than anybody foresaw. And you changed that deal during a time when your representation of that client made that a transaction with the client that was against their interests. That sounds tedious, but it happens with some frequency that lawyers are forced to renegotiate that deal, maybe charge a flat fee rather than hourly or whatever. Those changes have to be done with some care, and at the very least, you want a written conflict waiver that says the terms have been discussed, they're understood, they're fair and reasonable, that the client's been encouraged and afforded an opportunity to seek separate advice, and so on. And once again, even if it's boilerplate, get it signed before you change the agreement.
Okay, so that's the wordy stuff. Tison, talk about the software stuff that would help with billing.
Yeah, I mean, when the reality now is that to stay competitive, you have to offer various types of fee agreements. Clients have more leverage than ever to force you to be creative in how you get paid. And in order to deal with that, it's important to have a billing software system that is flexible enough to allow you to keep track of the different types of fee agreements. And really there are two main types. You can have the dedicated billing software, or billing software that's built into a more general practice management software that will help you with organizing your matters and contacts and everything like that as well. And within those two divisions, there are two other divisions where you are looking at server-based software or cloud-based software. And server-based software, it's more of an upfront cost. I mean, it may be $800 per user, and you have to, for the licensing fee, and then you have to purchase all this equipment. And for smaller firms and attorneys, it's often better to go with the cloud-based, which is maybe $20 to $40 a month. And so you have, some of the common ones that people use a lot are PC Law, time slips. Those are the server-based ones. Right now, a combination that is being recommended and I like is to use something like Cayo for practice management, and then if you want it will do time and billing things, but if you want it to have a little bit more workability, you can add Xero, Xero. And those combined seem to be intuitively designed and flexible enough that you can deal with these new types of fee arrangements and keep track of it in an easy way.
And Tison, to be clear, I mean, they're both server-based, right? What you're talking about server-based is you control the server, and cloud-based is it's somebody else's server under their control.
Correct, yeah. Okay. I mean, nothing is
There's
actually
no
in the
real cloud.
clouds.
That was
it is
news
on
to
a
me.
server farm somewhere, and we won't get into all the security and issues. I will say that if you are afraid of doing anything on the cloud, don't be. You need to do your due diligence and ask the right questions to make sure all of your information is going to be secure. But that's, I mean, under the ethics rules, that's really your responsibility. But don't be afraid. It's okay to use the cloud.
And you can help with that in terms of which.
Right. Yeah. If you have any questions, you can call into Practice 411, and we'll set you up.
All right. Any questions about fees, billing software? We're going to move on to file retention and maintenance.
Katya, could the panel address suing for fees? Some malpractice carriers, of course, look very unfavorably upon that. We at WILMIC, we're not going to drop policyholders necessarily if they sue somebody for fees, but
once.
One time. And some lawyers that I've talked to about this, some say they would never sue for fees under almost any circumstance because they believe it'll bring on other problems, such as a counterclaim malpractice suit, or they believe that it's just not worth the trouble. Could the panel talk a little bit about that?
Well, sure. First of all, I think it's, what dollar amount is at issue. If it's a few $100s, I would forget about it, both from a business perspective and a risk perspective. It just isn't worth the time and effort and headache. As you get up into larger amounts, I think you have to make a judgment call as to why the debt exists. Did you have a falling out with the client? Was there something that came up in the case that maybe you didn't foresee and you have that guilty feeling about it? In those situations, not a good idea to pursue it because you will face a counterclaim. On other situations, it's just purely economics. If you've done a trial and the trial took 2 extra days and the money wasn't there and the client, has no problem with what you've done and there's an amount due and owing, you certainly have the right to pursue that and get a judgment on it and do that from a business perspective. But by and large, I would agree. You don't want to be anxious to be suing clients. It's not good for business, and it can bring on some other problems for you.
Yeah, I was kidding about the once. That's not the underwriting standard at WILMIC. Sally had a claim once that arose in response to a suit for fees against the client, and the client said they had long been unhappy with the lawyer's work. And the lawyer said, I never heard that there was any unhappiness with the work. And the client said, well, they were subliminally objecting to the lawyer's work by not paying the fees.
That could be useful in a whole sort of different areas, I feel like.
Sure, children, spouses.
Passive aggression.
Yeah, that, also known as passive aggressive. All right, we're going to move on to file maintenance and retention. Basically, from our perspective as a malpractice carrier, we really like you to hang on to your files. That's not practical. So, Kevin, what's your advice on keeping files and in what form?
The longer the better, and completely the better. Now, that can become impractical. I've kind of approached this with a rule of thumb of at least 10 years. I don't think that's required. I've seen fee agreements from other attorneys that have addressed that and have talked about 2 years. So I think you have to pick which is best for your situation. There are certain types of files that once completed really are completed. And those you have a little less hesitancy to dispose of. There are other files that may include information that you expect to come back just because you represent people or families or businesses, and it's part of the ongoing situation, and you may keep those files for 20 years. You have to recognize that the files belong to the clients. They have access to the information that's in those files. It's a good idea to consult with them before any files are culled. But in certain situations, your letter at the end of representation can address that to some extent, and you can feel comfortable disposing of files if you're comfortable that the action is done and over with.
Well, at the risk of sounding like a ninny here, I have to agree that you should keep them a minimum of 10 years. And the client's permission to dispose of the file is irrelevant to my thinking. I mean, we want to conform with their expectations about how long you'll make that available. But for your own protection, the 10-year statute of limitations it's referred to as a statute of limitations, and it really isn't so much. It says that a grievance should be filed within 10 years of the time the client knew or should have known about the nature of the wrongdoing. So, and at any time during which the lawyer concealed that wrongdoing from the client, that 10-year period has not yet begun to run. So you can see just how mushy that 10-year limitation is. And I represented a lawyer who was complained about concerning the fees of a divorce case 10 years previous. And that was a very good lawyer doing very good work who really could not have reconstructed the good work that he did without benefit of the file, which mercifully he had access to. So it's a big burden to maintain this file, particularly paper files. But I think we really are well advised to do it, both for protecting ourselves against malpractice claims and grievances.
Yeah, I think there's the problem is also the flip side. It's so much easier to keep electronic files, and we keep so flippin' much material. If you're corresponding by email and you have these chains, and then you keep each one separately. So Tison, how do you give us some advice here on maintaining electronic files in an accessible form?
Accessible form. Yeah, I mean, you're required to keep all your files, or you're required to make reasonable assurances that the files you keep are protected, safe, and can be, or in a format that can be easily given to your clients. And I think digitizing your files and keeping electronic files is the easiest way to do that. And the three things that you want to think about are storage, organization, and file search. So storage, to keep it safe, obviously you're going to want backup, and I like to use redundant backup, a combination of both on-site backup with an external hard drive, or if you have a larger server, then separate hard disk space, or in addition to that, have a separate cloud backup. And for firms under 15, there are some excellent programs out there like CrashPlan or Carbonite that will allow you to set when things are backed up, both in the cloud and on site. And you could tell any kind of file system or any place where they're kept to be backed up, and there's a lot of flexibility there, which is great. When it comes to organization, you want to think about what works best for you. I like to imagine like a case you worked on 5 years previous. If you were wanting that file right now, what would be the easiest way for you to find that? Do you want to look by your client? Do you want to look by the date? You just want to think about how you want to name your files and organize them, and it's not going to be the same for everyone. What works for you may not work for someone else, but to make all those files easily accessible, you want to have a good file search or retrieval system, and that sometimes will involve a full-fledged DMS or document management system like World Docs or NetDocuments. Some of the practice management tools like Time Matters have built-in functionality that you can use. But if you're running a simple office, you also most of your operating systems, Windows or Mac, have Spotlight on Mac or just Windows Search on Windows are pretty powerful tools. And then there are some kind of in between DMS and those lesser tools like File Center. It's like less than $200, I think, and it works with local or cloud storage, and it'll even allow you to set up rules for automatic naming of files. So you set the rules ahead of time, like if you want to go by date and then a code for the matter type and then the last two letters of their name or something. You can set that, and then every file that you create will automatically do that. So there's a lot out there, and you also want to be sure that you have OCR, optical recognition capabilities, if you're going to use PDFs. I like to, anytime I have a final document, keep that in PDF. So anytime I see a PDF, I know that's a final document. Other people like to have separate folders for here's the original and here's a PDF. But if you want to be able to search words within PDFs, you need to make sure that you use an Adobe Pro or another piece of software that allows it to create those words in a searchable format. So yeah, if you have any more questions on that, please contact me. But you really need to be thinking about how you want to organize it, and that's the most important part. Because
do you notice how it's only when Tison speaks that anybody writes anything down?
That's a good thing.
As it should
I know.
be.
Yeah.
Lawyers always had to figure out how to file things, and my favorite filing system is the emotional filing system. This is the stuff I want to deal with. This is the stuff I don't want to deal with. This is in between. Kathleen, you wanted to add something?
I'll just add that I'll tell you, there's 5 lawyers in our office, and we have an off-site storage facility that I think has almost 40 years worth of files in it. So we're in the process right now. I have to say I have been trying to, get practice management software, cloud-based operating and file storage going at our office. But one of the things you can do to simplify these matters, and this is really just a dovetail on what Tison said, of course, you really should consider electronic storage for all of your files. First of all, it's searchable in a way, as long as you do the things that you were talking about in terms of PDFs, that paper files are never going to be. It's going to be less costly in the long run and, frankly, less risk. We did actually have a flood in our storage facility once, and luckily it didn't hit our particular one, but after that we were like, okay, we need shelves to actually put these things on. I mean, it's just things like that you have to worry about. But in terms of volume, that's something you can get under control, because I think all of us, at least in our office, we tend to just keep everything with regard to a file. At the end, right, Katya thinks, yay. At the end of it, though, at the end of whatever matter it is, you really should purge your files even before you store them. So get rid of things that they're really, duplicate copies of agreements. And there are a host of those things in your files, I'm sure, as there are in ours, so that by the time you're storing them, either if you're physically storing them or electronically storing them, you're not storing 400 pages worth of documents. You've got your execution copy of an agreement. You've got, the final orders for the case, the original pleadings. But you don't have, the 6 drafts of discovery that you did that, really no one will likely ever need. So you really can manage that volume, even if, and as the other gentleman here was saying, you do need at least 10 years. So that can add up very quickly. But I think if you purge early on, right before you send it to storage or do whatever you do, you can minimize some of the difficulties you'll have there.
I'd have to take a little issue that sometimes drafts of documents show the extent to which the client was enfranchised in the decision-making reflected by the eventual document. So, again, at the risk of being tedious, that can be useful. That may remind you 3 years hence, that you did share drafts with the client. The client made changes, maybe insisted on changes that later on come to be the subject of some criticism. So,
yeah, I think that's certainly true. You just have to use your judgment on those things. Yeah.
Yeah, happy clients, maybe you can store less.
Right.
I thought I'd also add.
Tom.
We have a question from a web viewer. Could the panel comment on whether complex letters of engagement and retainer agreements should be tested by Flesh Kincaid readability testing software to enhance communication to the client's level?
That's a good one.
I'm not familiar with that.
Okay. we will respond accordingly then.
And we're not either.
No.
I would like to add back to the document storage. If you are digitizing old documents, or if you want to start digitizing all of your documents, I would start with your open files. There's really no monetary value in, there's not as much value in messing with the older files. Start with your new files, the ones you're currently working on, and worry about the older ones later. And be sure, if you have in your digitizing process, as you're scanning and you're wanting to get rid of old originals, if there are wills and things that you can't just destroy, be sure to get receipts from the clients once you give them those originals back, and then digitize those and keep those receipts.
Hey, this is where the emotional filing system comes in, because once you're done digitizing your open files and then you start working on the closed ones, start with the cranky people first, because those are the most likely ones to complain. You'll need your work to defend yourself. Tom?
Another web viewer question. How can you keep electronic files accessible when software constantly changes? Which of the software that Tison mentioned will be readily accessible 1, 10, 20 years from now? Will PDF files even be accessible after a new format is developed?
To bring your crystal ball.
Yeah, well, I imagine any kind of software in the future will have some sort of backwards compatibility. PDF is pretty broad right now, and I don't see that going away. So I wouldn't be worried about what types of files you keep. And as software changes, really it's going to be the searchability functions that change, not the way you store it. So I wouldn't be too worried about future-proofing.
You aren't old enough.
I think you have to keep up with it, and if you know you've got your files, I mean, I just moved, and that whole issue of plugging like new electronic boxes into old electronic boxes, they charge you more for those freaking cords than they did for the electronic boxes in the first place, and they call them legacy cords. So right now you can still buy a cord to plug an old DVD player into a new TV, but I'm guessing in a couple of years that will no longer be available. So you,
I literally do have every electronic file I've ever created, and everything older than maybe 2000 is completely inaccessible.
inaccessible.
What types of files?
The operating systems change, and does anybody have AppleWorks or ClarisWorks in whatever version they had in those years? Good luck.
Well, I did come across some people who were starting to use Macs, and they used to use WordPerfect documents, and they had all these WordPerfect documents that they wanted to open on the Mac, and with since Mac went to an Intel-based system, they can no longer read those, so you have to look for a converter, and there's always going to be some kind of converter.
You can't even read the old Mac documents. I've always been on a Mac, and you can't even read the old Mac documents.
On a Mac, no. Yeah, so I think you have to contemplate reconverting your converted
A lot
files.
of those things are on SCSI hard drives.
Well, you can come talk to me afterwards.
Fortunately, those are more than 10 years old, but
Yeah.
it's naive to think that the electronic compatibility is not an issue in the future.
Well, but I guess I would say that even when compatibility is an issue, there are other people in your situation, and that usually means that there is a conversion process. So there's some product out there to help you with that.
All right, we have a question right here.
I just wanted to contribute one quick thought. I used to work in IT, and I spent a lot of time with 3 1/4 floppies and 5.5-inch floppy disks, and it's not so much necessarily the file conversion, but does anybody here remember what a zip disk is? Yes. Does anybody still have a way of getting files off a zip disk?
Find the right cable.
And
Legacy cables.
Maybe sometimes it's better to just keep everything on a central server and just keep moving that along rather than relying on old storage mediums, because in my own experience, I've had old burned CD-ROMs no longer work just due to the medium itself.
Okay.
So it's paper.
Paper is another suggestion.
I think that's another argument for the cloud.
All right. I'm going to go down the panel and ask each speaker to give us the takeaway they want you to have after this program. I'm going to start with Kathleen.
Okay, a takeaway. I guess I would just say that no one should hesitate to get involved in social media. You can always start small. It's incredibly user-friendly, and there's all sorts of content on the web that you can use to create content, and that, like I said, you can start small. You can start with a few paragraph blog on your own website and just branch out from there. So everyone should get started, especially because so many of us now are relying on Google searches and technology to generate new clients.
All right, Tison.
Along those lines, I would like people to take away that just don't be afraid of new technologies. Attorneys, in particular, we like to get stuck we are stuck in our ways. We like how we do things, and we don't want to change. But I think when you do make those changes, a lot of times you'll wonder why you waited so long. I've heard that story so many times from people who waited on upgrading their systems, and really just don't be afraid. And if you have questions, there are resources at the bar to help, and there are resources elsewhere, and you don't have to make those changes by yourself.
Thanks. Kevin.
Continued communication with clients. The worst thing you can do as an attorney is say, okay, I completely understand your situation. Let me take care of it. I'll get back to you when it's taken care of. That's the worst thing you can do. So the letters, the emails, the sit-down meetings, continued communication all the way through, and that'll work well for your advocacy and your billing and your reputation.
Richard.
Well, two things. One, I mean, I can joke about being part of an analog group here, but we have to be fearful about not keeping up with technology, because there's a lot of elements of competence that are going to require that we understand, how to protect our confidentiality against metadata mining, and whether we're obliged to do it ourselves. All manner of communication with clients, all manner of issue connected with the practice of law is going to require that we maintain some familiarity with emerging technologies. And the second thing, and maybe an overarching thing, is look out for yourself. I mean, we're trained and we're inclined to do everything we can to look out for our clients, but lawyers are very poor at looking out for their own interests. They will fail to document an agreement between them and their client that later comes to be vexing. They'll fail to do that, and they would never do that on behalf of the client themselves in dealing with a third person. So protect yourself. Look out for yourself. There's a lot of pitfalls out there, and lawyers are always credited with being the all-knowing in whenever controversy comes up later on down the road. And I find a lot of lawyers who are very guileless, very generous, and very poor at looking out for themselves.
All right, there is a paper evaluation. Hang on just a second, I will get to you. We really want you to fill it out, because if this was not what you wanted, or if you wanted something different, it's so helpful to us in planning future seminars. If you're on the web, you will get an email on Monday asking you to do an online evaluation. Tom has a question.
You want to squeeze in one more web viewer question?
Sure.
Are
That's
there
a good one.
Are there types of cases, such as guardian ad litem cases, where you could destroy without as much worry? I assume they mean destroy files.
Well, I think the answer to that is whether things can be duplicated. I mean, I think of a guardian ad litem file, if reports or documents are filed with the court, you're always going to have access to those. If you're doing a real estate transaction and the deed is recorded, that's 90% of the worry. So, sure, I think there are files that lend themselves to being disposed of easier than other files.
All right, I am confident there are more questions that need to be answered, and I'm confident a number of those don't have exactly clear scientific answers, but I'm hoping this was helpful. I appreciate the panel. I thank you for your work, and I thank you for your attendance.
Good job.
Thanks.